Mr. McKinney, you say that immigration courts are not real courts. You are, I'm sure, aware of the fact that executive branch agencies employ administrative law judges across a broad sectors of the federal government. For example, the Department of Labor houses the Office of Administrative Law Judges. The Office of Administrative Law Judges also do similar work at the Drug Enforcement Administration, among others. If immigration courts aren't real courts and lack the basic due process and independence that you think is necessary, does that raise your concerns? Does your concerns apply equally to the other functions that these administrative laws, the other subject matter areas that they operate in?
Well, thank you so much for the question, Senator Cornyn. I don't want to claim to be an expert in those other fields, but from my review in working on this issue, in other settings, administrative law judges simply have more power to act like judges.
They're not independent, though.
They are not, in some cases, they are not fully independent, but they are.
In none of the cases are they fully independent. They're part of the executive branch, right?
Correct. Ultimately, it's the administration that is in control, that is running the federal government.
Judge, I don't know how you handle what comes at you and the volume that comes at you. I can't imagine having to do that day in and day out. It just seems overwhelming. And maybe we need to look at some of the inputs that cause people to end up in front of you. But right now, if somebody is, let's say, detained at the border and claims asylum, how long will it take them to get a hearing in your court?
In my court, if they had been issued a notice to appear, and they would probably get a hearing within maybe 5 months for their initial master calendar hearing, at which time I'd provide them with some information about their rights. Then they'd want to probably have some time to seek representation. And
so do you agree? I think somebody mentioned the typical time period for adjudication of these immigration cases could be up to 3 years.
I think that's fair.
And I've seen actually some reports in New York newspapers that some immigration courts have backlogs of up to 10 years. Is that accurate?
I can say that I agree that there are some courts, because it's a different distribution of cases around the country and different numbers of judges. Some of them do have very extensive delays.
I noticed that according to the Executive Office for Immigration Review adjudication statistics for the third quarter, that the median asylum grant rate is 12%. The mean court asylum grant rate is 16%. So, and I noted in your court, if I'm reading this correctly, the grant rate is roughly 30%. But my question is really about the 70% in your court, or the 86% in courts across the country that are clogging the system, that people who ultimately will have no legitimate legal basis to claim asylum, that are impeding access to the courts by people who actually have legitimate claims. I think we all agree that people with legitimate claims should be heard and should be granted asylum. So, but don't the people who don't qualify make that hard?
When the system is as overburdened as it is, it takes time to find and get to those cases that are meritorious. But we are required by the Constitution to provide due process even to those individuals that don't have ultimately a meritorious claim.
Well, I understand that, and I'm not criticizing you by any means. I'm just saying that the current system, for lack of a better word, there's really no system. It's just helter skelter. But it does create a situation where there's backlog because of the sheer volume. Mr. Stimson, you know, years ago, maybe 2 years ago now, maybe less, In a town, little sleepy town in South Texas, Del Rio, Texas, it's 35,000 people. 15,000 Haitian migrants showed up and claimed asylum. They'd been living in South America for the previous few years, and so clearly they had transited a safe third country. Would eliminating the ability of individuals to transit a safe third country to qualify for asylum in the United States, would that help address some of just the sheer volume that we're seeing these days and act perhaps as a deterrent that would discourage people without legitimate claims from showing up at the border?
Thank you for your question, Senator Cornyn. Yes, of course. And I would add that 12b-6 and judgment on the pleadings is due process, as I explained at length in my written testimony. And so the notion that a case with no merit whatsoever needs to languish for 3 years in a court system where people with legitimate asylum claims, who we can all agree need to have their cases heard and they need to be granted asylum, it's not fair to them. And so 12b-6 and judgment on the pleadings is part of the due process that we afford in all state and federal courts.
Thank you. Senator Hirono.
Thank you, Mr. Chairman, for holding this hearing. Before I proceed with